Welcome and thank you for joining Seyfarth's webinar, Updates on California Pay Reporting Requirements. All participants are in listen-only mode. You're encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the presentation. At this time, I'd like to turn the program over to Annette Timon.
Welcome, everybody. Welcome to the webinar. In terms of the legal disclaimer, just making sure that you all are aware that we are providing this information for informational purposes only. As you know, we're attorneys, right? So you're probably familiar with the disclaimers. Any advice that, any information that we're sharing should not be construed as legal advice or a legal opinion on any specific facts or circumstances. We encourage you to talk with your legal partners as you go through this process. I certainly would like to welcome you and would like to, as we move to the next slide, you'll see the agenda and sort of what we have outlined for you today. It will include a background on SB 1162, the key changes to the paid data reporting under the law, what employers and labor contractors will need to work on together to provide information to the state agency with regard to reports, and then practical takeaways. I think I jumped ahead to the agenda and didn't properly introduce the team. So you're going to be joined today. Obviously, my name is Annette Timon. I'm a partner here at the firm. I'm also joined by Sharday Scahan, who is also our partner in our California office, and Joe Velli, who works very, very closely on all these issues with regard to compliance and reporting, and certainly the California pay data reports as well. So we are going to do our best to provide you with as much information and context in a with regard to changes that are coming very quickly based on the information that is currently available. I can tell you that today, since this morning at around probably 7 o'clock or so Central, and sometime around 10 o'clock, there have already been changes to some of the information that was put out. So this is quickly changing information. So there's a new user guide. So it's important to level set there. So with that, we'll go ahead and turn to the next slide, where we're just going to give you a bit of a refresher on the California pay data report requirements. So this, for many employers, is not going to be new, right? So since 2020, California, that's when they first implemented their pay data reporting requirements. That first filing was due in March of 2021. It applied to employers with 100 or more employees that had at least one employee in California and who were required to file an EEO-1 report. It also only covered those employees of the private employer. There's been a few changes that came about, and they're pretty significant. So it's certainly broadening the scope of the requirements. So SB 1162 was introduced February of last year. It was signed into law September 27th. There were some FAQs that were just released January 20th. Over the weekend, a technical user guide was released. You may want to keep track of the versions because we noticed that that's when I mentioned earlier, version 5.0 was released over the weekend. Version 5.1 was updated at some point this morning. There are Excel templates that we were aware were going to be posted today. There are some out there. There's at least 2 out there. I will say this, at least with regard to the labor contractor report, based on our review this morning, it doesn't seem to line up with what the user guide information is. So be looking out for that. I think something is going to have to get updated. I'm not sure if it's the user guide or if it's the Excel template that is up there for the labor contractor report. We have sent out a message to the state agency. So be mindful when you are downloading information. Up until yesterday, the Excel templates were literally the templates from last year. So just because there is an Excel document, take a close look at it and make sure you're using the FAQs and the user guides as you go through the information. So let's talk about, on the next slide, we'll talk about the key changes, right? So I talked about the pay data reporting requirements that apply with regard to private employers, and those have been in place. We now have new timing starting with the filing for 2023 that's going to cover your 2022 data. The deadline is going to be on May 10th of this year. So the timing is a little bit has been changed a little bit, and that is going to now, you just pick the second Wednesday of each May. Every year, that's going to be the filing deadline, as long as there are no other changes. But that's, you can put that on your calendar. Second Wednesday in May of each year, the California pay reports are going to be due. The new scope that we're seeing is sort of that's what we're going to spend our time talking about today. The first is that it requires reporting even if an employer does not have an EEO-1 filing requirement. So for most employers, most private employers, there's nothing new for you. For staffing agencies and some third-party labor contractor organizations that do not have an obligation to complete an EEO-1 report, that is going to be a new requirement for you, right? So you will have an obligation to complete a California pay report covering the workers that you send out to your client employers. So those will now be included if you're a staffing agency or a temporary contingent agency that provides contingent labor. It also covers employees and labor contractor workers. We're going to define what that means because that is an important definition that we need to level set on. So it's going to include more than just your own employees that are on your W-2 that you pay on, that put on your payroll. There's a couple new pay data requirements as well. That's the median hourly rate and the mean or average hourly rate. So new data components as well. And there's an entirely new report. So in addition to what we're going to call the payroll employee report, I should say what California has defined as the payroll employee report, there is now a new labor contractor report. And so employers may have an obligation to complete one or both of the reports. If we move on to the next slide, we'll see the two report types that we're talking about. So the payroll employee report is going to be what's been familiar to most employers. It's going to cover the W-2 workers that you employed during the selected snapshot period. The labor contractor report is new. It is a second report. And we're going to talk about who has to provide that report, but it is going to cover the W-2 labor contractor workers, that is in quotes because that's a defined term, that performed work for a client employer within the client employer's usual course of business during the selected snapshot period. I will tell you that labor contractor is defined. We're going to talk about that shortly. However, the definition of what a usual course of business has not been defined. That has been coming up, I will tell you, in conversations already. The FAQs do not provide clarity on that information. So on that specific point, I would encourage you to talk to your counsel, look at it internally to determine precisely what is meant by usual course of business and how that applies to your workforce. For some employers, this is going to be a fairly straightforward process. For others, this new data report is going to be quite cumbersome, and it's going to require a lot of back and forth between now and the May 10th filing period. I saw a question that came up that said, does the due date for the California report tie out to the EEO1 report? It does not. These are separate reporting obligations. There's some common terms, but also some very different terms in key ways, so the deadlines do not align. If we go to the next slide, we've provided you with, and these materials are going to be included, shared with everyone who signed up and registered, but we've included some key definitions here. So I'm only going to cover a couple of them because we're going to, between this slide and the next slide, cover a few of them because these are the terms that we're going to be using today. So client employer is a private individual, entity, or other person that has workers hired through labor contractors. So in that sense, think about the traditional employer who employs individuals. To the extent you also have labor contractors that you use, there are in some places we're going to refer to you as a client employer. Certainly a staffing agency is an employer as well. Sometimes they, depending on which hat they're wearing or which report we're talking about, they might also be a labor contractor as well. A labor contractor employee, so this is going to be the new reporting obligation for many employers. A labor contractor employee is an individual that's on a labor contractor's payroll, and it includes part-time individuals for whom the labor contractor is required to withhold Social Security taxes, so federal Social Security taxes from that individual's wages, and who performs labor for a client employer. So the most obvious group is if you work with a staffing agency and they send to you temporary workers, those employees are paid on the labor contractor's payroll, but they would now be included on, or potentially depending on the date frame, but they would also then be included on your labor contractor employee report. So that's who we're talking about. And then if we go to the very next slide, the payroll employee is the other definition that I've highlighted there, and that is an individual on the employee's payroll. So these are your typical employees that you would have always included on your existing California reports. You pay them, they're on your payroll, and you pay them W-2 wages. So these are the types of terms that we're going to be using as we review the requirements coming up. And with that, I'm going to turn it over to Sharday, who's going to talk to us about the snapshot period and the implications for anchoring the date as employers and labor contractors work together to provide the reports.
The snapshot period is kind of the starting point when you're figuring out the scope of your report. You might be familiar with the snapshot period if you already filed the payroll employee report in the past. If this is new to you, then we'll run through kind of the key points that you need to know about this. But essentially, for both the payroll employee report and the labor contractor employee report, the snapshot period is going to be a single pay period between October 1st and December 31st of the reporting year. It's as simple as that for the payroll employee report. It's just that single pay period. For the labor contractor employee report, it gets a little bit more complicated because the client employer and the labor contractors can choose to collaborate on a snapshot period, so can work together to select which snapshot period is going to apply, or just one party can choose the snapshot period. But again, this is why we say conversations between the client employers and the labor contractors are really important to have early and to have often, because this is one of the first points that's going to tell you on whom do you need the data. The client employer can use the same snapshot period across labor contractors. We know that there's a lot of employers that work with a number of different contractors. So if you choose to, you can use the same snapshot period across different contractors. but that is not a requirement as well. So the snapshot period is going to tell you the universe of employees on whom you're going to include in your report. So you're not only reporting the hours or wages for that specific snapshot period. The snapshot period is just the tool that you use to figure out who should be included in the report. And the reason that you're using a snapshot period is because people come and go throughout the year. So this is intended to be a method that you can identify the scope of the employees on whom you're going to be providing the pay data. On the next slide, we will talk a little bit about who is going to be filing. For the payroll employee report, we're looking at private employers with 100 or more employees who were employed during the snapshot period, or quote unquote regularly employed 100 or more employees during the reporting year. Regularly employed means essentially that they work in the nature of a business that maybe they don't have a full calendar year's worth of employees. Maybe it's a seasonal business. So during their season, they employed 100 or more employees. But if you looked over the course of the year, that employer might not have employed 100 or more employees. So the regularly employed question is not necessarily going to apply to everyone. It really just is going to depend on the nature of your business. You also will be required to report after you meet that requirement if you have at least one employee who was working within California or assigned to a California establishment. So that can include an employee who you have who lives in California and has been teleworking from home or working remotely from their home in California. So if you meet that requirement of the 100 or more employees, plus you have at least one employee who is working within California or is assigned to a California establishment, then that tells you that you're going to need to be prepared to file a pay data report. The employee count for the initial threshold question of whether or not you have the required 100 or more employees, that's going to include employees in California and nationally, but you're only reporting on those employees who are working in California or assigned to a California establishment. Also, to determine whether or not you have 100 or more employees, you are going to include your part-time employees and your temp employees if they are on your payroll. For the labor contractor employee report, it is a little bit of a similar consideration. Again, you have that 100 or more language, but you're looking at whether you have 100 or more labor contractor employees, and that's across all labor contractors. So again, if you work with multiple labor contractors, you're going to look at how many labor contractor employees you've worked with across all of the labor contractors. So you're adding everyone together to figure out whether you meet that threshold. And again, it's either during the snapshot period or regularly employed during the reporting year. So for our purposes right now, the reporting year is 2022, the calendar year of 2022. You also have to have at least one labor contractor employee who's working within California or assigned to a California establishment, and those are the labor contractor employees on whom you're reporting. Those who are working in California, teleworking in California, or assigned to California establishments. Again, for the threshold count of whether or not you have that 100 or more labor contractor employee threshold satisfied, you are going to be counting your labor contractor employees nationally, but you are reporting on the labor contractor employees in California or assigned to the California establishment. On the next slide, we are going to quickly hit on the integrated enterprise issue because this is a question that we've gotten a lot. If there are other entities, how are we reporting? Is it all one report? Is it separate reports? The intention is that if you're a separate legal entities, each legal entity is filing a separate report unless you can satisfy this requirement that you are an integrated enterprise. So if there's an entity that has fewer than that 100 employee or 100 labor contractor employee threshold, you're only going to report if you're part of an integrated enterprise and that number hits 100 or more. So we've listed the factors on here that you would evaluate to determine whether or not you are part of an integrated enterprise and thus can file a single report. We highly recommend that you work with legal counsel to conduct this analysis to determine whether or not you meet the definition of an integrated enterprise. Otherwise, each enterprise or entity is going to be filing separately. On the next slide, we will discuss now who is going to be included in the report. So we kind of mentioned that a little bit when we're determining the scope issues, but for the payroll employee reports, you're reporting on employees who are employed during that snapshot period, whichever payroll period you selected, and again, assigned to a California establishment or working from California. So that would be an employee who's working remotely, and there's a number of employees these days who are working remotely. So you want to keep track of whether you have employees working remotely from California and know that they need to be reported on as well, or if they're assigned to a California establishment. If you have an employee who's assigned to a California establishment but goes to work at a client site outside of California, those employees are also included because they are assigned to the California establishment. For the labor contractor employee report, it's going to be similar. You're reporting on the labor contractor employees who worked for the client employer during that snapshot period, and you have the same requirement of assigned to a California establishment or working from California. And even if that labor contractor employee is working at a client site outside of the state, they still would be included as long as they are assigned to a California establishment. So you want to make sure that you're analyzing both of those factors when you're determining whether or not these employees are going to be included in the report. It's key to remember that you're including the employees who were employed during the snapshot period. So you don't want to confuse yourself by trying to pull in other people that you know started at a different point during the year. You're just using that snapshot period to figure out who's going to be included in your report, and that's going to be the scope of employees or labor contractor employees who you work on. Now, on the next slide, we highlight the information that you are going to be reporting by establishment. Again, if you filed these reports in previous years, this is going to look pretty familiar to you. You're reporting and grouping employees by race, ethnicity, and sex, the EEO job category, which are published, pay bands, and this is based on W-2 Box 5 wages, hours worked, and then the new requirement, the mean and median hourly rate. Similarly, for the labor contractor report, you're reporting on those same factors. A few things that we wanted to highlight about these factors: if an employee only worked a partial year, you are not going to be annualizing their earnings. So you're only going to be using the earnings from their W-2 Box 5 wages. So even if you know that their salary is $100,000, but they worked a partial year and they only earned $50,000, if $50,000 is what is on that W-2, that is what you are using. You're not going to annualize their wages. Also, for the labor contractors, the pay and hours worked for labor contractor employees, it's supposed to be apportioned by client employer. So depending on how much this labor contractor employee worked for a specific client employer, then you're going to be apportioning that their hours worked and their pay for the client employer. So that's a new requirement with this labor contractor report that the CRD came out with in their new FAQs. So if a labor and contractor worked for multiple client employers throughout the year, you have to figure out about how much time that labor contractor worked for each client employer and then apply or apportion the amount of wages and hours worked appropriately for each client employer. For this year only, the CRD is not going to be assessing penalties for failing to include race, ethnicity, and sex data in the labor contractor employee report. You still need to include that in the payroll employee report, but for the labor contractor employee report, there's a bit of a reprieve this year if you do not have that information to include in the report. Annette is going to now cover a few other key pieces of information and data that you're going to be collecting for that labor contractor report as well.
Okay, so before we launch into the the data, right, in terms of how we go about capturing all this information. At this point, you're probably asking yourself that, right? How this is a lot of data, and I've already seen questions about how do we collect it, who should collect it. I also wanted to answer just one global question is we are referring to the term labor contractor because that is how California has defined it. But to be clear, this is only your W-2 employees, whether they're your own W-2 employees or they are on the W-2 or the payroll where the employer is required to deduct Social Security taxes from them. These are not your contractors as defined by it paid on a 1099. So I just wanted to clarify that because I was seeing that question come up. So just to clarify that point. So let's, figure out the data, right? This is, if we go to the next slide, there's a couple of ways that as we thought about this, there's a couple of ways that employers may be able to work on putting the information that's needed together. I will say this is really going to need to be a collaboration between the client employers and their staffing agency or third-party labor contractor partners. You're going to have to work together on this in terms of how you define the snapshot. For example, as Sharday mentioned, the CRD did allow employers and labor contractors to report on different snapshot periods. So you can talk through how you're going to do that. But as we see it, and we're going to show you two summary data points that come from the user guide, at least as what was available just before this presentation. But we see this sort of in two ways. You're going to have to work together, and one option is to request that labor contractors provide a summarized data set. The obligation for filing is going to be with regard to the private employer. You're going to have the obligation to provide data for your employees as part of the payroll employee report, as well as gathering and collecting the information that's needed for the second report. I think there are some ways that you can work with your labor contractors, assuming they have certain data points that will allow you to provide the information in a more summarized way. But if for some reason they don't have information, like, for example, the specific legal entity that these workers were employed at, or the specific establishment that they went to. For example, if you had a temp worker that worked remotely, does the staffing agency know, or the labor contractor partner know, what establishment? Because there's going to be a tie-in between those two data points. The second option is going to be to collect employee-level data from the labor contractor. That's obviously going to be much more cumbersome, but there's no requirement, at least that we've been able to see, that the agency has defined who's responsible for providing what. This is going to be a collaboration, certainly for this year. And as you move into, the future, having, deeper discussions with your labor contractor partners about timing and all kinds of data points is going to be really, really important. So let's just go to the next slide so I can try and show you what the information appears to look like. So essentially you'll see two grids. Hopefully you can see this okay. And there's two slides here. So one is sort of the gathering of mostly the employer information. The way the user guide is set up, it's kind of connecting some of the template materials together. But in the top grid, you'll see that it says payroll employee report. So this should be similar to what you've seen in the past. There is some employer information that's provided on another tab, but then you're reporting each line by an establishment name. There's an address. You're providing the total number of employees at that particular establishment. You are listing on that specific line, you're describing for that particular job category, and this is an EEO1 job category. This is a 5, the race, ethnicity, and you see there the example that the agency gave is B60. It's a combined code that combines the race, ethnicity, and sex. You're going to provide the pay band. The pay band is established by CRD. The pay bands are the same for both the labor contractors and private employers. So you're going to include the number of employees that are in that particular pay band, and then you're going to provide the mean hourly rate as well as the median hourly rate, and then the total hours. The next grid, just below on the same page, then starts providing information about the third-party labor contractor, right? So it lists, again, the establishment name, but then if you'll see that under kind of the darker green section, it still says employee detail. I think that that's probably should be labor contractor detail, but it refers there to Pete's team on that first group. It requires the client employer to provide the labor contractor's FEIN. The snapshot that the labor contractor used, and the beginning date and end date. So both date ranges are included on there. Then when we go to the next slide, you'll see a little bit more detailed information. It repeats some of the information at the top, but now it says, you know, the second grid at the bottom further reports to, or further describes the labor contractor employee report. And you see that these are, there's some examples for establishment A, right? And it lists the number of employees at the establishment. And then you'll see Pete's workforce and Ann's workforce, right? It's provided in a couple of different ways. So rather than a client employer providing all of the data, right, with regard to a particular establishment that says this is the number of employees that came to me from a labor contractor on one line, it is detailing, it's being provided for each labor contractor separately. So that is a really important distinction, and that is why my comment earlier about potentially a labor contractor partner could provide you with this information if, for example, they are able to, you know, to total up or provide the aggregate information about how many labor contractor employees it sent to you, the client employer, that reported to a particular address at, you know, 123 Broad Street, and they also knew the legal entity. And I will tell you that in talking with our clients so far about this, sometimes at first glance, the belief is, well, no, we don't share a legal entity. But typically, if you dig a little bit further, hopefully it's there, perhaps in the billing information. It'll say like who's paying for these workers, or for one employer, there was a GL number that they could use, a GL code, and that GL code was listed on every request for temp workers that went out, and based on that, they were able to break out what the legal entity was. So there might be ways. So you just have to, you know, get together and sort of determine whether or not the information might be housed and where it might be housed. So this, I'm hoping that the template materials that the CRD put out today are going to be updated to match what's here. If not, I think they're going to have to reconcile that a little bit more, because at least what we saw this morning, there was a little bit of a discrepancy in terms of how some of the data was laid out, but at least this gives you a picture of what is currently in the report, because that is something that we had been anxiously awaiting to see exactly how this was going to be laid out, especially with regard to the labor contractor employee report. So with that, I'm going to turn it over to Joe, and he's going to talk a little bit more about the specific data needs.
Yeah, great. Thank you, Annette. So for those of you that have gone through the reporting process in years past, you know that the way they collect the data is essentially broken down into three specific parts. One is for employer-related information. The other is for establishment-based information. And then the other is that employee-level data that you need to construct the reports in the format requested. So this first wish list essentially is everything that would be required on the portal when you're going in and inputting your employer information. So you need your name, you need the FEIN tied to the company, you need the California SEIN for that legal entity name, the NAICS, the address information, and then it starts to ask a series of questions regarding whether or not you're a state contractor, whether or not these are US-based employees or your California-based employees, and providing the total headcount for each, the snapshot dates being utilized, whether or not there's any corporate affiliations or similar ownership structures. And then last but not least, what's the point, who's the point of contact for the report being sent into the state, and also who's the certifying official if that is different from the point of contact. And so what was originally part of that report structure in the first year of reports, this has now been embedded when you go in and register your company with CRD and start inputting all of these company specifics. So it's on the portal itself, but still critical to collect. So whoever you are utilizing internally to start collecting these data, they should know at a minimum, these are all the data points that we will need to complete this year's reporting obligations. This will also carry through to that labor contractor employee report as well, because as you'll see on the next slide, it's almost just a continue add-on here. The next 4 slides are going to be, okay, we start here, collect these data that are necessary, and then move on to now establishment name, establishment address, that establishment's NAICS and major activity, the total employees at the establishment, and then it asks the series of questions. Was a report filed for this establishment last year? Was an EEO1 report filed for this establishment last year? And is this establishment your corporate headquarters? We then further go into what is required for the labor contractor report. And so while all of this information is critical and will be critical to the labor contractor employee report, you'll see that there are a couple distinctions now when we start collecting the information for the labor contractor report that's required. On the next slide, please. So there's a bit of a disconnect right now in the templates that have been released and the user guide that we've been reviewing. The templates, based on the user guide, the templates should have these categories that capture your labor contractor name, the labor contractor FEIN, and the labor contractor snapshot dates that are being utilized. If you download the templates, you're not going to see those fields now, but if you review the user guide, you will see in the example, just as Annette showed us a couple slides back, that there are columns for this information so that you could distinguish which labor contractors are being utilized at which of the client employer establishments, how many of those labor contractors are at the client employer establishments, and what are the snapshot dates being utilized. I know a lot of things that are confusing some of our clients and employers is this fact that not every single labor contractor that you use must use the same exact snapshot date. And I think that is why the state originally built in these additional columns to show, yes, while this data is being collected, yes, while we're reporting, it's not all the same snapshot period being utilized. So it gives the state the opportunity to see how the data was being constructed, how you were determining the contractor workforce being utilized. But this is all built in, step 1, identify all of that corporate client employer information that you need. Step 2 is really collect all that establishment information. Step 3 would be identify those establishments that are actually utilizing labor contractor employees. And once identified, being able to pull in these additional labor contractor data elements. And then as you'll see on the next slide, as far as the employee and labor contractor employee data elements, we've covered this in the prior slides. Race, ethnicity, and sex is needed. EEO1 job category based on the job title that those individuals sit. W-2 box 5 wages for your employee population for that payroll employee report. As Sade said, do not annualize the wages for partial year employees. That is not how you want to report that data. For hours worked for those employees, for your non-exempt, we want the actual hours worked and any time that they were on PTO, such as vacation, holiday, sick leave, paid, anything that was paid. We want that information for your hours worked to be calculated and reported. For exempt, it's a little bit different. This is actual hours worked and time on PTO if you're capturing that data through timesheets. But in the exempt, for your exempt population, you do have the option to use an average hours worked and average hours on PTO. So if you're a full-time employee, and you were employed for the full year, as an example, you could use hours of 2080, or if you were a part-time employee, you could use hours worked of 1040. So the FAQs do give you that option. It's not as strict as your non-exempt population. And then we need the data to be able, that individualized pay data, so that you're able to calculate the mean and median hourly rates, because that is that new reporting requirement this year. And so that individualized data will assist you in making those calculations. For the labor contractor employee report, when you're having the conversations with the labor contractors that you utilize, as you know, we'd love to get race, ethnicity, and sex data, but for at least that 2022 reporting year, we have a little bit of leniency. So if that data is not being collected, or that data is difficult to ascertain, there won't be the CRD is not going to come down on you for not having that data in year reporting year one, but get those processes established for year two. That EEO1 job category, as far as the box 5 wages here, is an important distinction, is that for the labor contractor employees being utilized by the client employer, the only wages that should be reported are those applicable to each client employer. So if someone happens to work for multiple client employers at the same time, or there was some differentiation over the course of a year, we don't want the total earnings that labor contractor employee had. It's only those tied to the specific client employer that they worked for. Same thing with hours worked. We want the actual hours worked by that employee for each client employer. So it shouldn't be aggregated. It really should be individualized, reported individually based on the client employer report that this pertains to, and allocate those hours accordingly. And same thing, we also have that mean and median hourly rate calculation to report here. So whether that is being done by the client employer based on individual individualized level data, or it's being done by the labor contractor themselves, this will be reported this year. So if we move on to the next slide, I'm going to talk about PEO considerations. So here, we just want to make you aware, this is nothing new. This was also as part of the obligations last year, that if you utilize a professional employer organization, just keep in mind that the PEO may not submit the reports, that they can't submit a report that includes multiple employers, multiple legal entities in one filing. The PEO may prepare your reports and submit for the company, but they can't certify. So they could assist up until that certification point, but there has to be a company representative that is aware of the accuracy of the data being reported, that is in fact doing the certification. And as the state says, it's the ultimate responsibility of the company filing their reports, with the state, not the PEO, to ensure that the data you're providing is accurate. And with that, I'm going to turn the presentation back over to Sharday. But before doing so, we do have a CLE code that I want to provide you. That is SS9465. I'll give it to you one more time. It is SS9465. And with that, I give you Sharday.
Okay, so one of the big questions that is on everyone's mind all the time are data privacy concerns and then also confidentiality concerns with all of this data that we're collecting and submitting to the Civil Rights Department. So the pay data reports are protected from disclosure by the CRD and the DLSE. So these pay data reports are not going to be publicly disclosed, but information in the statute itself, it says that the information cannot be made available before instituting some type of investigation or enforcement proceeding, either by the CRD or the DLSE. There was an attempt to add some kind of public disclosure element last year when the amendments were kind of going through the California legislature, but that was ultimately taken out. So no public disclosure of the reports. There still will be aggregate reports published. Even today, you can see aggregate information if you're curious about what that looks like on the pay data reporting website. So it's not going to be tied to any particular company, but it just shows you the breakdown of various demographics and data that the Civil Rights Department received as part of these pay data reports. After you certify the report, you are going to be able to see a chart generated showing a representation of the data that is provided. And it's very important throughout this process that you're just being very careful as far as data collection, and when you're working with the labor contractors, that you're discussing what type of processes you need to put in place to ensure that the data remains as confidential as possible. If there is any sort of inquiry into the data or request for the data, you certainly want to consult with legal counsel right away if you receive any requests for that type of information. And there are objections that you would want to make, of course, if there is an inquiry into the data or request for the data. And things that you're going to be considering are, what are the types of data that you are keeping private or considered to be protected information? How would disclosure of this data be harmful, or in another way, how would it be valuable to your competitors or to others? And then, is this type of information already publicly available or not? What type of information is requested, and what's already out there versus what would be disclosed with the information being sought? So those are a few things to consider when we're looking at the privacy concerns and confidentiality aspect of these reports, and then the information that is being collected for preparation of the reports. So if you do have to file a labor contractor report, definitely engage in communications with your labor contractor to determine the procedures that are going to be followed for the collection of the data and providing that data to you. On the next slide, we have an example of kind of what it's going to look like when you have that certification submission charts, and this comes directly from the user guide, the currently updated user guide. So this is just a viewing of what type of data you will now be able to see in the portal once you provide your report and submit your information. So it essentially is just going to be a graphical representation of the information that you provided to the CRD, and then you also will get a proof of certification after you submit. So the CRD continues to update the portal each year. I think they're still trying to figure out what works best, what information they need to provide, et cetera. So this is a new feature that we're seeing this year, and then you can also download the information if you'd like as well. And then as far as enforcement is concerned, on the next slide we have an overview of the enforcement mechanisms for the pay data reports. You might recall, if you were previously required to file the report, that there weren't really any penalties that were associated with these reports. There could be an enforcement action to try to make you comply, but no penalties. So now there are penalties associated with noncompliance. So you could be subjected to penalties of $100 per employee for failure to file, initial failure to file, and then $200 per employee for subsequent failures to file. There's going to be no PAGA actions or anything like that related to these California paid data reports, but the fine still could get pretty hefty if you have a significant number of employees, and now you're looking at $100 or $200 per employee if you are not complying with this requirement. The CRD, Civil Rights Department, can also seek an order requiring the employer to comply with these requirements and to seek costs as well. And I'm not sure if we mentioned this at the beginning, but just a note, if anyone was reading this and confused, the CRD is the same thing as the DFEH. They renamed last year. So if you're looking at the term CRD, just think DFEH. It's the exact same administrative agency that would be enforcing this law. And then the labor contractors are required to supply all necessary pay data to the client employers by the statute. So that, again, is why it's important to work with the labor contractors to make sure you have everything that you need. The statute or the FAQs do define pay data as all the data that must be reported to the CRD. So basically, any information that you're going to need to complete those labor contractor employee reports from the labor contractor, that labor contractor should be providing. So you should be working together on that. Penalties may be assessed against the labor contractor if they do not provide the information that you need to submit a complete and accurate report as well. So penalties can be assessed against the client employer, or there is an avenue that penalties might be assessed against the labor contractor as well. To close us out, Annette is going to discuss some of the more practical takeaways that we have with this amended pay data reporting law.
Okay, so as we wrap up, I mean, this is a lot of information that we're sharing, and we're on our end are certainly distilling a lot. CRD is updating materials, but there's a lot of information here and a lot of moving parts. So we certainly encourage you to make sure you've got a team of internal stakeholders who are able to really track down, chase down the information that you're going to need to provide. There really should be collaboration, coordination between client employers and your labor contractors. Part of the first step that some employers are really struggling with is really defining the relevant labor contractor partners that they should be coordinating with. We do encourage you to reach out to your labor contractor partners. Keep in mind that not every client employer that uses labor contractors are necessarily going to have to provide these reports, right? Certainly, if you have the threshold number of labor contractor workers, then you will have an obligation to provide that information, but your labor contractor partners may not necessarily know whether you hit that requisite number. So make sure you're coordinating with them. You're going to be talking about the snapshot dates that you're going to be using. You'll be talking about which employees and how to identify those. Some employers may want to share the specific locations that you use in your California reports. And by that, I'm talking about the establishments. So what are your brick and mortar establishments that you're actually reporting on that may or may not be known to your labor contractor partners? You're going to need to take a look at what you currently share, what information they have, how much detail they have available. What are the timelines, right? So this is due May 10th. So backing into that, what's the kind of drop dead date by which you need that in order to work internally if you're doing them yourselves or working with your partners on putting together the labor contractor report and the private employer report? Thinking about the data transfer process, Sade alluded to that. I did want to bring up one other issue that might come up in the litigation context, but certainly how you're going to share the data back. For some employers, if you've got, 3 or 4 specific labor contractor partners that you consistently use, you have it well tracked, documented, you know who they are, and it's a very coordinated process, this is going to be fairly seamless. But there are some employers that use, potentially hundreds of third-party labor contractor firms. And so coordinating that information, figuring out who it's all going to, how you're going to house it. Is there a specific, are you going to use an FTP transfer site to report, compensation data back and forth, or how the mechanics? I know that sounds really basic, but this report is very much one of those in the weeds kind of report. So we're actually talking fairly high level in terms of who to include and not to include, but those people who are actually going to be responsible for putting this together, especially if you have a large, contingent workforce, it's going to be somewhat cumbersome and more like an administrative, how do I gather and compile all this information? And then, making sure that once you get the data, how are you going to take all that information and put it into the format that's needed so that you can comply by that May 10th date. And then all those pain points that you are going to discover as you go through this process, right? Begin implementing strategies for the upcoming year. How are you going to go about better tracking? What's an easier way of, getting this information updated, tracked back and forth? Many labor contractors did not previously track race and gender information. So that's something that may be newer to them. And so working with your labor contractor partners on that overall, I'm referring to that as change management. What are all the pieces that you're going to need to address going forward? With regard to the litigation aspects that Sade touched on, if you saw that, that dashboard essentially, right? That really what that's saying is based on an EEO1 number for both your private employers and labor contractor workers, there's some data and there's some reports that California is putting in a dashboard for you, right? It's really important that sometimes, I do see down the road in the litigation context, it may not affect everybody here, but I certainly could see discovery requests that come up seeking this information. And whether or not that's going to be disclosed, especially if you have a pay type of case in California, whether that's going to be disclosed, is going to be subject to the discovery and the, litigation federal rules of evidence and state evidentiary standards as well. So just be mindful that your legal partners understand the kind of reporting and the compliance issues that are going on, because as we get more detailed information concerning, alleged pay differences, or where women are as compared to men based on these averages and means without no data really, right, with no data about the actual job that someone's working or all the key variables that we consider when we're thinking about compensation. That's really important to really understand what these reports are and how it could come up potentially in litigation. We've answered a lot of questions, and so let me close out, or we'll get to the very last slide here. And this is where you can go to. The CRD does have a website. This is the same website that they've had that requires, this is where you're going to use the actual portal. Is there? I believe it has been updated, at least as of last night. The portal seemed like you could pop in your contact information. It may require a new password or login information. It wasn't exactly clear to us when we were looking at it yesterday, but it might require you to log in. So if you submitted reports last year, certainly go through, log in, and see if you can get through the system. If not, make sure you're looking at the technical guidance that the agency has put out so far. In addition to the FAQs, this is what we based our webinar on. Look at the FAQs, take a look at the portal, look at the user guide that was updated today, keep track of the version that's up there, take a look at those Excel templates, and make sure you're talking with your labor contractor partners sooner rather than later. There have been lots and lots of questions. We've done our best as other members of our team have been on to answer as many questions as we could get through. We thank you so much for your participation here. We are certainly available to assist with your reporting needs and any questions that you may have. So thank you so much for joining us. We really do appreciate it.